When we broke last night, um, uh, we had taken a half hour public comment, and we had broken into the department's cross-examination to do that. The way
that we noticed up, though, in my pre-hearing order, public comment sessions was noon and 5 yesterday. The rest of this week, it will be 9 and 1. So let me just ask if there's anyone here for the 9 a.m. public comment. Anyone in the room? Just wave your hand. No. Is there anyone on the platform here for the 9 a.m. public comment period?
I am.
There will be 7 more chances, including at 1 o'clock today. Is that someone?
Oh, there it is. Yes. I don't know.
Are you unmuted?
I am here. I don't know why I am not showing up.
Pam, can you share the name? I can't read it from here. Oh, okay. Terrific. Ms. Christodoulou, can you speak up, please, so that we can hear you?
Okay, let's make sure I'm... All right, I'm at the max. Can you hear me?
You appear to be unmuted.
I know. Let's see. Can you hear me? Let's see what's wrong. Microphone. Can you see me?
I'm sorry. They're saying they could hear her online. I'm not sure if it's an issue with us.
You just can't hear her in the room. Pam, do you need to ask for IT help so that we can hear? Oh, he's right there. Okay, great. Thank you. Okay, we wouldn't normally. You
Can
wouldn't
you
normally
hear
do
me
that in
yet?
hearing, but I'm happy to put their names on the transcript.
Mr. Maxwell, can you hear us? I just want to see if it's her or just the whole system.
Mother, yes, I can.
No. Oh, okay. I can't hear you either. Thank you. Thank you.
Ask him if he can speak.
Okay, Mr. Maxwell, I'm sorry if you wouldn't mind saying something just to make sure I could hear you.
Yes, testing. Can you hear me?
Perfect. Perfect. Thank you so much for your help. We always appreciate it. So I think we're good now, Madam Hearing Officer.
Thank you. Ms. Christodoulou, can you speak up at this point?
Can you hear me?
Yes, if you would speak just a little louder.
Okay, thank you.
Thank you.
Is that loud enough?
Yes, that's perfect. Do you
Oh,
swear
great.
or affirm to tell the truth?
I do.
And if you would please spell your name for the transcript.
Okay. Athena, Athena, Christodoulou, Christodoulou.
Thank you very much. I'll start your 3 minutes now.
Commissioners, my name's Athena Christodoulou. I'm a retired Navy commander, an environmental and energy engineer, tech entrepreneur, and Christian living in Albuquerque. My first hat is environmental engineer. And so we're going to go over what produced water is. Produced water can contain, besides oil, where it comes from, a myriad of known and unknown compounds, including known hazardous materials. And to quote Shakespeare, a rose by any other name is still a rose. In other words, you can name it anything you want, but it doesn't change its properties. To mimic the bard, I say hazardous waste by any other name is still hazardous waste. And hazardous waste still has to be handled by the polluter as hazardous waste from cradle to grave, even if diluted, i.e. produced water. The entire amount must be disposed of properly and expensively. If someone wants to make money, get into the hazardous waste disposal business. And let's call produced water what it is. Diluted hazardous waste. Make the oil and gas industry pay for the hazardous waste they produced, not the taxpayers of New Mexico in a shell game where we are always the loser. Let's remember the uranium mines and the tailings which have polluted land, water, and air, leaving us to once again pay the price with poor health and high cancer rates. Where are those companies with their bags of money? Off enjoying Mar-a-Lago and Acapulco. Oh, wait, not Acapulco. Probably not now. Not since Hurricane Otis came in November. Hurricane Otis developed from a tropical storm to a Category 5 hurricane in less than 24 hours, and it wasn't even predicted to go past Category 2. And now, something else to think of. Our plant hardiness zone maps have changed in only a decade. Those are the maps that tell us when and where we should plant certain plants. My trees are suffering. Am I going to tell them to pull up their roots and walk north to get out of the heat? And let's talk about Dubai and how pollution can spread even when we don't want it to. They got rain, enough rain to cover 2 years worth of rain in one day. That meant all that water picked up all the dirty soil, all the pollutants, and spread around for everybody to enjoy. They weren't planning on that. So I don't trust anyone who has lied to the people of the world for decades and now our planetary systems are truly out of whack. I don't trust them. And as a Christian, I say stop lying and killing us. You murderers will stand in judgment from God for destroying our earth. Let the people of New Mexico live with clean air, land, and water. Thank you.
Thank you very much. Is there anyone else on the platform who would like to offer public comment at this public comment session? There will be 7 more opportunities. Pam, will you tell me the name? I can't read it from here.
It's Carlos Matutes. He's on
Okay,
your list.
Carlos Matute. Can you hear me, sir?
Yes, ma'am, I can.
Oh, good. And I can hear you. Do you swear or affirm to tell the truth?
Yes, I do.
And would you spell your name for the transcript?
My name is Carlos, last name Matutes.
Thank you. I'll start your 3 minutes now.
Thank you very much. My name is Carlos Matutes, and I represent Green Latinos. We are a national organization dedicated to fighting for environmental justice for Latino communities and other communities of color. I'm here today to testify on behalf of all people of New Mexico. As you all probably know, we have the largest Latino population per capita in the entire nation. That means that our community, nuestras comunidades, are being adversely affected by pollutants at a higher rate than other communities. This produced water ruling is, to put it quite frankly, a boondoggle. Produced water is nothing more than toxic waste. And let's be very clear on public record. What petroleum companies are using additions to fracking water are considered trade secrets. Not only are there no scientifically verifiable methodologies for treating this toxic waste, But there can be no scientifically verifiable methodology because we don't know exactly what is in these fracking chemicals. Essentially, we're putting in our water supply in the desert chemicals that we don't know what they're doing. We do know that we have known carcinogens like benzene in high amounts in fracking chemicals. And as you probably all know, there is no safe max or minimum amount of benzene allowable. This is a highly dangerous chemical that is in virtually every fracking compound. I ask that we refuse to consider reusing toxic chemicals, no matter how much they're diluted, until we can have a verifiable methodology for treating this toxic waste. I request that produced water not be allowed in the state of New Mexico because it is our people, our environment, our future that is at stake. Thank you.
Thank you. Is there anyone else on the platform who would like to offer public comment this morning? Please raise your hand or reach out in the chat.
Madam Hearing Officer, I see Emily Lucas that has her hand raised as well.
I'm sorry, I couldn't hear you.
I'm sorry. Emily Lucas. She also
Emily
Lucas.
Lucas.
Hi, can you hear me?
Yes. Ms. Lucas, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. And would you spell your name for the transcript, please?
Yes, my name is Emily, Emily, Lucas, Lucas.
All right. I will start your 3 minutes now.
Thank you. Good morning, Commission members. My name is Emily Lucas. I'm from Albuquerque and a member of Youth United for Climate Crisis Action. As some of you may know, studies have found that there are PFAS, also known as forever chemicals, in the blood of nearly all Americans. Additionally, research has shown that there are forever chemicals that greatly exceed safe levels in most rainwater around the world. This so-called produced water contains various chemicals that are dangerous to human health. Among them are PFAS. And it is clear that PFAS impact human health negatively. The risks include increased risk of cancers, changes to the immune system, and low birth weights, to name just a few. Expanding the use of produced water will lead to more spills and more exposure to these chemicals. We need to be removing these toxins, not opening up a new avenue for them to spread into our water and soil and ultimately into our bodies. I would like you to consider who benefits from allowing more use of these hazardous chemicals. Despite shiny language, it's clear that the oil and gas industry are the ones who stand to gain the most. And who is going to bear the costs? The public, farmers, and the workers that directly interact with the toxic chemical fluid will suffer the costs unmitigated. There are no scientific standards for safety, and there is no requirement that cleanup of a spill will be paid for by the polluter. Instead, it will most likely fall on the public. We need to limit the spills instead of increasing their occurrences, which is what will happen if quote unquote produced water is used more widely. Policy should benefit the public as a whole, not just a tiny few. And as a young person, I am very aware of the state of our environment and water and what it will look like for me when I'm 60 and for the generations that come after. Please consider the long view and what this would mean for the decades to come. We cannot sit by and watch as the place that we call home is contaminated by toxins. And we will not sit by as our loved ones suffer the consequences of putting profit over people. Thank you for your time.
Thank you, Ms. Lucas. Anyone else on the platform wish to offer public comment at this time? The next public comment session is at 1 o'clock today. Anyone else? Hammer Madai, would you read me a name, please?
There are two people with cameras on. One is Jane Yee and Jeffrey Haas.
All right. Let's start with Ms. Nee. Can you unmute yourself? Let's try that. Ms. Nee, the administrator has unmuted you from this end. You may have to unmute yourself on your own machine. So. Do you see that you're being asked to unmute yourself on the machine? Is there a chat message there, Pam?
Yes, she says she doesn't have any commentary at this time.
Oh, all right. Remind me the name of the other person.
Jeffrey Haas.
Mr. Haas, did you want to offer public comment?
I don't see him on the platform any longer.
Okay. If there is anyone else on the platform who would like to offer public comment at this time, please speak up, turn on your camera, or reach out through chat. Whereas I'm going to move back to the technical case, and we will have another public comment session today at 1. Pam, let me know.
Yes, I will.
Okay, I think we'll move back to the technical case at this point. When we broke into the technical case yesterday afternoon, again, we were in the middle of questioning of the department panel. This is Dr. Hu, Ms. Murphy, Ms. Fulham, Mr. Herman, and Ms. Lucas Kamat. Thank you. Excuse me. And when we broke, Mr. Chair Thompson was wrapping up his questioning. Let me go back to you, Mr. Chair, and ask if you had additional questions of the department panel.
Thank you, Madam Hearing Officer, and thank you to the panel. I appreciate your work, and I have no further questions.
All right, thank you. Vice Chair Armstrong, do you have questions of the department panel?
Yes, thank you. Just a few. Morning, folks. You know, yesterday in your testimony, you highlighted your experience, and I was just curious if, for the record, you could tell us as a group the collective experience in years of the folks testifying on behalf of the Environment Department.
Madam Chair.
Counting.
Madam Hearing Officer. I'll get it together. Madam Hearing Officer, Mr. Chair, Commissioner Armstrong, I believe it may be in my rebuttal testimony. I believe it's over about 100 years. I have over 25 years. 25 years.
Yeah, I have over 25 years.
I have close to 18 years.
30 years for me.
7 years.
I think that does put you over 100 by my mental calculation. So thank you for that. I think that's relevant. You all have been doing this work for a long time. You've been through these types of rulemaking processes before, and you implement these types of regulations every day. And I think that's valuable for everybody to recognize. Yes, absolutely. I got 2 of them turned on. And I'm hearing myself, but I'll try to speak louder. My next question is because I heard some comments and opening statements yesterday from other parties and in the public comment. I just want to clarify, does this proposed regulation authorize any funding?
No.
Okay, thank you. Simply put, this body doesn't have the authority to authorize any funding, correct?
I believe that you guys are authorized to manage the Clean Water Revolving Fund, which is not within the Ground or Surface Water Quality Bureau and would not be related to this activity at all. And that would be the only funding that I know that you guys have any control over whatsoever.
Thank you. In my last set of questions, or really single question, it might turn into more, is picking up on Commissioner Brankard's line of questioning yesterday. This notice of intent has been on the commission's mind recently. We sent a case back to MNERD and the Oil Conservation Commission because they had gone through a notice of intent process and not a permitting process. So my curiosity is why a notice of intent and not a permit process here?
Thank you for the question, Madam Hearing Officer, Mr. Chair. The notice of intent process that we've designed in this new regulation is intended to be that, a new notice of intent process that shouldn't be compared to the other notice of intent processes. But they relate to each other because we used the existing notice of intent process to build this one and to understand what we needed. And we developed it in order to essentially finalize our using of the old notice of intent process improperly. We've been using it, we've been shoehorning it into our process, but it's not the right way to go about it. And with the information that we will be receiving from these notices of intent, it's designed to give us the comfort level that we are doing the right thing and that it's being protective.
So I said it might lead to a couple other questions. One that I do have based on that. Yeah. So as part of the notice of intent, I don't know what we call them, applicants, entities, are required to provide, I want to look at the language here. They're required to submit to the department all research results, including lab analyses of all water contaminants in the untreated produced water and treated produced water. Is that a level of transparency that is new or in addition to what they would currently have to provide?
Absolutely. Right now, the existing notice of intent process simply states that they must estimate the water quality that will be in their actual discharge. This new notice of intent process for produced water specifically will essentially give the citizens of New Mexico something for their money when they pay us to evaluate those projects and to determine that there's not a discharge permit required for that activity.
And so I guess back to the bigger question of, why not a permit? Looking at the language that Commissioner Brankard highlighted yesterday from the Produced Water Act, it says for uses regulated by WQCC, a person requires a permit from NMED before using the produced water. In the Water Quality Act provisions that came from that Produced Water Act legislation, it talks about a range of uses and not just discharge. And so again, my question is, and I guess maybe more direct, like Commissioner Brankford was asking yesterday, not just why an NOI process and not a permit process, but it says in here that you're required to get a permit for the uses. The Water Quality Act provisions say you need to have permitting for discharge, handling, transport, storage, recycling, or treatment for the disposition being a broader term than discharge. So can you help us walk through that one more time, why we aren't legally required to have a permit process here?
So if you're looking for a legal analysis, I'll turn to my lawyer. But I can give you the department's position policy-wise and implementation-wise. We're looking at this regulation, the proposed regulation, as looking through the lens of the Water Quality Act at the Produced Water Act. And so we're fitting within the process, or we're placing the process within the idea that the Water Quality Act gives us the authority to require notices of intent submissions, and that we're doing impartial fulfillment of the Produced Water Act related to the disposition of produced water. And so we have a different interpretation of the language in the Produced Water Act than Commissioner Brankart has. We believe that the language is somewhat circular, and it only relates that those other categories of the items are covered under the Produced Water Act as they relate to the disposition of produced water.
And Commissioner Armstrong, I could hopefully add a little bit of clarity to that. Now that I have the act up, I can read it. The Produced Water Act states, for uses regulated by the Water Quality Control Commission. And in my interpretation of that, not being an attorney, I read that as not adding to the authority of the act itself. And then when we go to the actual Water Quality Act, it says we shall adopt regulations to be administered by the department for the discharge, handling, transport, storage, recycling, or treatment for the disposition. And so that part where it says for the disposition means that it's already within the authority of the Water Quality Act and doesn't necessarily add to other authorities. Because the act requires us to protect for ground and surface water and develop regulations, as it states in 74.6.4 as the duties and powers of the commission, is to adopt regulations or adopt standards based on scientific evidence. We do not have sufficient evidence to bring before the commission today to say that we could write conditions that would be protective of ground and surface water. So therefore, we are asking the commission to give the department the authority to implement a decision-making process so that we can review these produced water demonstration projects statewide and get information of what's going on with the research so that we can ever come to a conclusion as to whether it would be treatable or reusable. It may or may not. We just don't have that information. So I think as we've read the Water Quality Act in tandem with the Produced Water Act, it really only gives the commission the authority for the disposition, which is the intent of the act initially.
And to add on to the add-on, the question regarding whether this is a notice of intent process or a permit process, it is our contention that we are requiring the submission of information a single time up front in order to get us over the bar of determining whether a project is being protective or not. We're not requiring ongoing monitoring beyond the submission of the final research results that will give us the information that we need to further. And that was the people of the state getting the money, or getting the work product for the money that they pay.
Okay, thanks. One last question then. In that case I referenced earlier where this commission sent it back to the Oil Conservation Commission or division for final determination, we took issue with the lack of any public involvement or notice process. What does that look like in a notice of intent process?
Historically, we have posted the notices of intent and the entire project pathway onto our website, and that is the extent of the public notice process because of the fact that we're getting them over the bar of being protective. I think there's some clear differences between the OCD case and this process. I'm tangentially familiar with that case. I've read the filings on it, and I believe that much of the issue was actually stemmed from them not creating an administrative record on their determination prior to submission or prior to requiring a discharge permit or a notice of intent submission. We are, I think, in a different zone of regulations with requiring a category of water that's identified by the Produced Water Act as specific to us, or specific to the Water Quality Control Commission and the Environment Department.
And of course, I will add on a little. The other part of this is that we are making this NOI process for demonstration projects of produced water public through this rulemaking process. Whereas instead of in OCD, they were relying on the already established regulations in 20.6.2. So our attempt is to outline what is needed in each of these demonstration projects. Once we have that, we'll be able to provide it to the public either upon request or on our website so that it's transparent.
Thank you. That's all my questions this morning.
Thank you. Commissioner Polidoro, I think I see you on the platform or your name on the platform. Do you have questions of the department panel? In the event he reaches out, Pam, let me know. Commissioner McWilliams, do you have questions of the department panel?
Yeah, I have a few questions. Thank you for taking those questions today. Mentioned it just recently, the duties and powers of the commission in Section 11 of the Produced Water Act, Section P, shall adopt regulations for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition and road construction maintenance, roadway ice or dust control or other construction, or in the application of treated produced water to land for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil or gas. Is it your testimony that the legislature did intend for the produced water uses and discharges outside of the oil and gas industry?
Commissioner McWilliams, thank you for the question. I am unsure what the legislature had intended, but the way that the language currently reads is for the disposition as required under the Water Quality Act. And so, again, as we've testified, we believe that it's for the disposition within the regulatory authority of the Water Quality Act and doesn't necessarily extend beyond that.
Section of the Water Quality Act states the regulations adopted by the commission may specify a standard of performance for new sources that reflects the greatest reduction in the concentration of water contaminants that the commission determines to be achievable through the application of the best available demonstrated control technology, processes, operating methods, or other alternatives. Would there not be a reason, or why wouldn't you want to allow the discharge of produced water if the applicant can prove it is free of contaminants, carcinogens, PFAS, whether they run a full pollutant scan, those things that are achievable through the best demonstrated available control technology, processes, and operating methods?
Commissioner McWilliams, I'll start with this question and I will refer to our expert witnesses on the constituents in produced water. Our regulations in 20.6.2, which this is supplemental, would be supplemental to, and 20.6.4, which are our water quality standards, have constituents that we would expect to see in most sources of wastewater, being domestic and industrial. However, with produced water, as we've provided in our direct testimony and in our rebuttal testimony, the constituents in produced water are highly variable, and they are also unknown for the most part. We have some idea and we can treat for some of the constituents, but when you don't have source water characterization, meeting our standards in 3103, 20.6.2.3103 may not be sufficient for the protection of groundwater and human health. And this is where I'd like to hand it over to Dr. Hu to explain a little bit more about some of the known and unknown constituents and the studies that have been done and what that's highlighting for us right now.
Madam, Madam Hearing Officer, Mr. Chair, Commissioner McWilliams, as stated in my written testimony, the constituents found in produced water are diverse and variable, including elements such as water, grease, suspended solids, dissolved solids, heavy metals, natural occurring radioactive metals, dissolved gases, microorganisms, and a wide range of known and unknown compounds. Yeah. So based on a comprehensive literature review conducted by researchers from the Environmental Defense Fund, a total of more than 1,000 chemicals have been identified in produced water from onshore oil and gas production sites in Canada, Mexico, or the United States. And they include toxic organization and inorganic compounds. The physical and chemical characteristics of produced water from both unconventional wells and conventional wells exhibit a significant variability influenced by several factors such as geographic location, geological history, the type of hydrocarbon product being produced, and well age. So it's clear produced water is not uniform even within the same basin. So produced water contains a wide range of compositions from simple to highly complex. So therefore, making conclusion about its characteristics based on one or few studies is insufficient due to its variability. So that's the reason we need more detailed and region-specific studies to learn about the characteristics of the produced water.
Yeah, I agree with you on that there is a lot of variability, but I'm wondering if the applicant, if you will, could prove maybe there's a subsection of produced water that has less variability or has less contaminants that can be proven. Why wouldn't you put the burden of proof, whether or not they could, maybe it's unattainable, but if the burden of proof was on the applicant to prove the quality and maybe even the pollutants that are in it, the incentive I think would be there for them to provide data showing why this technology would work.
So thank you for the question. I think the demonstration projects are designed to get us that information. And from an implementation standpoint, I want to go through a hypothetical scenario. If someone were to submit an application for us, the type of permit that we would draft in response to that, to get us to the point of being able to allow for a discharge, let's say we would require reverse osmosis. It's non-selective. We know what it can do. We would require them to hold that water, test it, verify that they've removed the constituents of every single one of our constituents in 3103. These are things that I've just thought about in my head while going through it. And there would be a level of verification and consideration for that water that would make it end up being $14 a gallon to treat. And we would then be said to be creating an economic burden on, you know, it's a back and forth that we've just it's hard to comprehend a way that we would be able to do it safely without this information from the demonstration projects.
Along those lines, do the NOIs that are submitted become public record?
Absolutely.
So I guess my concern there is that this could limit innovation because the companies that are willing to put in the research and development dollars may have nothing left for their work because it becomes public knowledge to any company that wants to use it going forward. So I feel like this might the fact that it becomes public, I think is problematic business wise and could stifle the innovation.
Thank you for the question. It's one that we've grappled with since the very beginning. We originally, I don't want to let too much inside ball out, but we had a full rule drafted with confidential business information language in it back in 2019 when we started the process. The end result was the Water Quality Act says that data cannot be confidential. And so we have held on to that, and that we cannot promulgate regulations or that we cannot propose regulations based off of confidential information. We can require, or we can promulgate confidential business information regulations, or according to the Water Quality Act. So I feel like we are hand tied at this time, at this juncture, by the Water Quality Act to not require, to not allow for confidential data to be used in our process.
Could you not have the information be confidential to the public but open to the department so the department has really no?
No.
Okay, interesting.
No, sorry.
One more question is using the source of the water as a main method to classify the water as acceptable to discharge or not. Is that new? Is it developed for this specific purpose, or have you always used the source of the water to determine whether or not it was able to be discharged?
Thanks for the question. Yes. When we draft permits, we consider the source water with permit conditions specific to that type of wastewater influent. So domestic wastewater, we have standardized permit conditions that we use for those. Industrial, for radioactive liquid waste treatment facilities, we have specific ones for those. And so in effect, we do take into account the influent type coming into a treatment system. One of those other small quirks in the Water Quality Act is we don't generally have the authority to monitor influent. We are given the authority to monitor the discharge from the pipe. And there's some arguments in our regulations on whether or not we can regulate only at groundwater for the groundwater permitting. But essentially, a specific regulation for a type of water is anticipated in the dairy rule, the copper rule, and now in this rule.
All right, thank you. No more questions.
Okay, thank you. Commissioner Dominguez.
Thank you. I'm hearing off. Okay, I've got a series of questions here. Some of these I'll throw out to the panel. Whoever wants to be the victim can go ahead and jump on the question. I may get to a few questions that would be specific to a person's testimony. So My series of questions may not be quite as well organized as my colleague to the right, but bear with me on this. So let's talk a little bit more about the notice of intent. So this is going to go back a little bit to the conversation about NOI versus permit. In your notice of intent, it indicates this specific information has to be submitted prior to use. So I'm reading the last of the sentence of C1. So the NOI gets prepared before they can do anything. Is that correct?
Madam Chair, I keep doing that. Madam Hearing Officer, Mr. Chair. Commissioner Dominguez, my apologies. As far as your question, correct. They would have to submit the notice of intent before they begin a demonstration project.
Okay. So I'm looking at your amended version of the rule itself. So I believe that's NMED Exhibit 175. And you incorporated suggestions made by, I believe, Amigos Bravos.
Right.
So that's specifically item A3, which was the concentration of water contaminants in the untreated produced water used in the demonstration project, etc.
That is correct.
So if they have to submit the NOI prior to use, how can they do the research to find all the contaminants if they have to submit the NOI before they do anything?
Commissioner Dominguez, when they have the water, they will do a source characterization before they, so the water exists, whether they're not pulling the water up just for the demonstration project. And it is usually a conglomerate of multiple wells that they want to use. They would have to do source characterization. So we're not asking for the effluent quality, which is the end product quality. We're asking for the influent quality, which Mr. Herman discussed the importance of needing to know what they would be treating for, what is in that source water. And so I don't believe that that would be holding up the process, and anybody who wants to treat a wastewater should know what they are treating for in order to know what types of treatment methodologies they want to research or test.
Okay. I understand where you're coming from. Just the way that this is structured, the writing of it seems somewhat circular. And there's a concern there that somebody doing a project may go, well, I can't give that information because I have to submit the NOI before I can use the actual produced water.
So in preparation for this hearing, I was reading the 1973 Barnstormers, the hearing record for the original notice of intent process. And a similar concern came up from the commission at that time, that how can you tell what's in your effluent if you haven't even started the discharge at that time? And we're not necessarily looking for the exact quantities and concentrations. It's a matter of what is your expectation. You know these wells are coming from these formations. You know these wells are coming from these different companies or these different processes. What are the the known knowns that you have coming in. Give us the information so that we can make our decision based off of that information.
Okay, thank you. So along the same lines of NOI and versus permit. So let's assume with the scenario that a permit's not required. They proceed with a project. At the end of that, and they're required to submit the results of everything that came out of the research projects. That gets submitted to the department, correct?
Yes.
So this seems to almost get back to a permit requirement where you're asking for a follow-up result or something that you've decided. When I say you, the department has decided that does not require a permit. Therefore, your regulatory authority has somewhat been set aside, yet they're required to follow up based on an NOI.
Commissioner Dominguez, I will try and answer this one. Essentially, we put in, and you're referring to the proposed language in 20.6.4.8, 400. Two. No, there's a C2. Where it states persons implementing a demonstration project or industrial projects pursuant to this section shall submit to the department all research results, including lab analysis of water contaminants in the untreated produced water and treated produced water. This is to assist, and we tried to make this clear in the regulation. This is to assist the department in developing standards and assist the commission in promulgation of regulations for use of treated produced water. This language was specifically put in to try and fill in and tie in the Produced Water Act language with the language in the Water Quality Act, because at this time we have no authority over anybody to get any information in order to promulgate these regulations. And that has put us kind of in a bind at this point. So although this part, it's not for a permitting action, it is specific to meet the requirements under the Water Quality Act, which say that we will promulgate regulations. That's what that is for. And it is not a permitting requirement. Permitting requires routine monitoring and assertions. This is just to gather information under the act.
And I'll just add to that. I think the major difference in my head between a permitting and an NOI action is a permit is a permitting submission, permit requirement. A submission required by a permit would be for compliance purposes and compliance evaluation. And this is in a different realm. This is something that is not going to be utilized for compliance. It's going to be utilized for regulation development.
Thank you for that answer. That gave me another question.
Oh, goody.
So, under that scenario, if no permits required, they do the research project, and they do not submit the results to you, what then is your compliance tool?
Mm-hmm.
Because it's not a permit. Are you going to take away their NOI?
So no, thank you for that question. And I've thought about this. The Water Quality Act gives us the authority to find them in violation of a permit condition, the Water Quality Act, or the regulations. That would be a violation of the regulations, and I could enforce upon them with a notice of violation or an administrative compliance order.
Okay, thank you for that answer. The fee portion and the financial assurance portion related to the NOI, when would those two aspects kick in? Would those kick in when a permit's required? or if an NOI is just approved.
Commissioner Dominguez, you're referring to in the section where it says financial insurance in place to cover the cost of cleanup remediation in the event of a failure during operation.
Correct.
That's essentially spills happen. And under our current regulations 20.6.2.1203, we do have requirements to report a spill. Part of this NOI process is that they're demonstrating that it will not impact ground or surface water because it will not touch ground or the surface. However, spills happen. And so the cost of cleanup for something that we don't know the contaminants to and the extent that it could cause injury, we have asked that the commission consider this part of this submission to include that financial assurance, because there's been a lot of public comment about who's going to pick up the cost if something does spill. So we can assure that based on their actions that it won't reach ground or surface water. We can't guarantee spills. And so this gives the assurance that the entity that wants to do the demonstration project has the financial backing to clean up a spill in the event of a release, an unintended release.
Okay, thank you for that. The next part of that question was going to be, since some of the research that's been done is based out of our universities. Have you talked to universities about financial assurance and how a public institution will handle the financial assurance aspect?
Thank you for the question. Having been deeply involved in the Los Alamos National Labs financial assurance negotiations, we have not specifically spoken to the NMSU, UNM, or any of those groups, but I believe that we have the creativity to make sure that we are fulfilling this requirement of the NOI process and working with these institutions to ensure that they are able to do it within their bounds. With the DOE and DOD sites, we have changed the name of it from financial assurance to financial responsibility because they can only request budget from Congress. So in this case, I would see that they would need to go to their board of regents to ensure that they have that type of assurance in place, or that they have some sort of mechanism to make sure that there's a budget allocation process for them in place. So I believe we have the methods and means to make that happen.
Okay, thank you. And believe me, this line of questioning is more geared towards trying to get you guys the tools that you're needed, because obviously there's not the information to set standards, or at least for a lot of constituents. You need the data out of it in order to take that next step or so forth. So the research is important. And we understand that. To follow up on a line of questionings from Commissioner McWilliams, I'm going to circle back to the proprietary aspect. Being tied to a university system as I currently am, I understand many times researchers at a university setting still have eyes set on patent opportunities. And obviously for the private sector, that's key for them. If this rule gets structured where some of those opportunities are lost, I have a concern that the research will then be pushed out of state. This commission and the department then have no authorities. The research will get done. You will get zero results out of it, and thus we don't benefit whatsoever out of it. And it's a concern that I have that we're in the testimony. It's been talked about this rule will hopefully enhance research and so forth. I may be on the other side of the fence having the concern that it may push it underground. And that's more of a probably a comment than a question, but if you've got a follow-up comment, feel free.
Commissioner Dominguez, I think it's an important question, and it does follow up on the concerns Commissioner McWilliams brought up. And I'm going to try and elaborate a little bit more. As a state entity, being responsible and servants to the public, being transparent with data and information that could impact ground or surface water is what we do. However, we do recognize that there are a lot of proprietary chemicals that are used in non-conventional, unconventional wells, the ones that use fracking fluids. And that, based on Ms. Murphy's testimony, is the predominant source of excess produced water that's not already recycled in the oil and gas field. So we're in kind of a rock and a hard place when it comes to trying to implement research while still protecting potential proprietary or confidentiality with businesses looking to treat this. First and foremost, our job as the department is to protect ground and surface water. I see this in other states, and I will have Ms. Murphy speak a little bit more on the other states, because that has been brought up that other states allow for produced water reuse. And I will say, after reviewing her testimony, there are a lot of limitations on that, because likewise, they have to protect their resources as well and human health. Even in Texas, which does allow for, or has put out guidance for the reuse on projects for land disposal or land applications, sorry. They have an initial application process to do these projects that will cost thousands of dollars just to apply, because we're trying to strike the balance between research and then being overly burdensome. And Texas has taken the approach that they will allow you to do these demonstration projects for a very limited amount of time, but you have to sample for an extensive amount of constituents. And I believe NMED entered that as an exhibit as to the process that Texas takes. All the states are struggling. Most of the states that do allow for reuse of produced water is either coal bed methane water, which has a lower TDS, less constituents that are of concern, and non-fracked water. And at this point, before I get myself in trouble on things I did not testify to, I will actually give it to Ms. Murphy to elaborate a little bit more on that.
Good morning. I just have one thing to add, and it also comes back to Commissioner McWilliams' question. And in my testimony, I said, I was asked, does the proposed rule prescribe what treatment process a demonstration project should use? And so we're less interested in all the deep specifics of the process. We're more interested to know that at the beginning of the project, the water is thoroughly characterized. It's run through the treatment process, and then it's thoroughly characterized at the end. And we do have a best available technology in the Produced Water Research Consortium's guideline for sampling and analysis. And that is the NPDES Plus list, whole effluent toxicology testing and non-targeted analysis. So it's less important to us to have the specific confidential business data on the treatment process.
Thank you. Let's shift gears a little bit and get into some more specifics that maybe are a little more clear cut. So under your definition of wastewater, the last step or the last sentence of that definition indicates that dairy wastewater is not included in the definition of wastewater, correct?
Correct.
But in your definition of agricultural application, we're back to A1, agricultural application. Included in that is operation or maintenance of feedlots or animal feeding operations. Is a dairy not classified as an AFO?
Commissioner Dominguez, this gives me the opportunity to reiterate the importance of source water as a wastewater that is treated for use in an application or the discharge. So the wastewater is the source water, and so dairy wastewater is not included. However, agricultural application is a subpart or subcategory. Thank you. For the discharges. So someone could take domestic wastewater, treat it to a particular, and right now it's just a case by case basis in our discharge permits. We do have situations, but they could take that treated wastewater and use it in an agricultural application. So they could use it at a dairy or a concentrated animal feed operation. So that really highlights the need for separating and defining for implementation purposes, which this rule we hope will help us with, between a wastewater, which is the source that is going to be treated, and the application, which is where it is discharged.
Okay, thank you for that clarification. I was just wanting them to get it clear in my mind. Those almost seem circular within the definitions or exemptions. But thank you for that one. A quick question on flood irrigation application. Within that, you refer to low flow emitters. Help me understand how you're classifying low flow emitters, because in my career, low flow emitters more closely associate with drip irrigation than it does flood irrigation. So please expound upon that.
Commissioner Dominguez, that's a really good question. And I'll hand it over to Mr. Herman to elaborate further.
So it's definitely a adjacent issue. The idea being, when you're looking at the reuse of domestic wastewater, which these were somewhat drafted with the mind in our minds, that it's a matter of the contact of the water and where the water contacts and for what time frame that the water contacts the vegetation. So flood irrigation is closer, even though quantity is not an aspect that we're looking at. It's closer to drip irrigation than spray irrigation, which would aerosolize or have a different exposure route that we'd be concerned with. So it's more about the exposure routes that we classify them as.
understand that from given the change with the spray irrigation. It's something that some thought may need to be given to if and when flood irrigation application ever occurs. The person doing some things may have questions as far as how they can be in compliance. But that's helpful from that standpoint. I think a number of these questions are probably for Ms. Fulham. Around your testimony about two things: definitions in general and constructing the rule itself. So let's start with, if a term is defined in the statute, is it necessary to repeat it as a definition in a rule?
Commissioner Dominguez, in some instances, when the definition in the act is comprehensive and addresses all the components that are needed for implementation without interpretation, my job is to try and reduce the amount of interpretation and provide clarity to the regulated community and the public. And I'll point out the Produced Water Act in particular, because produced water in the act is very general. And the technical staff that we have here today have had to work through nuances which seem very obvious to perhaps the general public or to in passing. But the idea of flowback water, of the constituents in the produced water, is very relevant to being able to implement this rule, because we have heard in and out through technical conversations of whether that a certain component would even apply as being produced water or its effect. And when we're talking about produced water, and again, as Ms. Murphy says and talks about in her testimony, the location and the type of water that we're dealing with is unconventional, fracked, produced water that does have different components to it. So in the Produced Water Act, it's very general. However, for implementation purposes, we want to be explicitly clear as to what is contained. So occasionally we will take the language of an act and add to it for implementation purposes to provide consistent and clear implementation.
Okay, thank you. And you must have been reading my mind, looking at the term produced water, which is now utilized in both the statute and the proposed rule. Which, let's say something goes to court, if this is a legal question, let Mr. Knight answer it. If there's, which definition takes precedence?
I will start and then I'm gonna let Andrew, Mr. Knight, take over. The way being very specific to produced water, because that is one of the definitions that's very clearly in the act and in our proposed regulations. We took the definition of produced water. We did not take away from the definition in the act. We just added clarity onto it. And so I would say that I'll let Mr. Knight, we tried to do it in a way that the act is overarching, but this provides the clarity for implementation.
Is this on? Madam Hearing Officer, Mr. Chairman, Commissioner Dominguez. My words are not testimony, as I am not a witness, and I would just with that caveat say that for purposes in speaking in general terms, for purposes of implementing and enforcing this rule, we can define a term within the rule, and that's what it means when we're implementing and enforcing that rule. And if you're implementing and enforcing the statute, then the definition in the statute controls. And that is, this is not the only case in New Mexico administrative law where that occurs.
Thank you, Mr. Knight. I'll follow up then with another question. Is it not, I don't want to say standard practice, but is it not the court standing that if there's a conflict between statute and rules, statute overrides rules, correct?
Madam Hearing Officer, Mr. Chairman, Commissioner Dominguez, as a general rule, that is true, but as with everything in law, there are exceptions.
Thank you. I'm not that I'm anticipating a court case, but I'm trying to make sure the commission has to take everything into consideration here. So Ms. Fulham, I had a lot of testimony and additional testimony regarding the definitions that are included here that are not used or only used for other definitions. And maybe we'll focus more on those that are not used in the rule at all. So we'll start with the question of nothing precludes the department, as this rule has been stated, it's an iterative process that you guys are anticipating revising down the road as more of the pieces come together. Nothing would preclude the department of adding new definitions at that point in time as they become applicable to an amended rule. Is that a fair statement?
Commissioner Dominguez, yes.
And I understand the department's vision of trying to front load this rule with as much as can assist, not just currently, but as the process moves forward. One of my concerns is with any rule that it be as meaningful to the regulated community as well as the general public. I had multiple people in my agency review this rule because my first review, I was confused, so I just pawned it off on other folks. Every person came back with the same comments about, I'm trying to find out where food crop application used because I found the definition, therefore I'm assuming it's used. And I believe not just from some of the public comments, but other parties' technical testimony, there's some issues there. I have a concern that we get misinterpretation, more so from the general public, that people think produced water can be used to produce food crops in this state because they've seen a term. As a regulatory agency, I know you guys have a view of it that may be different than the general public. And I would encourage you to look at some of those terms that could be misinterpreted. It gives me pause. So, I know you testified that State Record Center Administrative Law Division reviewed it for style and format. Would you agree with me that that's their rule? That's their role, is to review for style and format more so than for content?
Commissioner Dominguez, yes. The Administrative Law Division's role is to ensure that it's consistent with the regulations for developing New Mexico Administrative Code. And part of that would be whether it meets the legislative style format, the relevant portions of that.
Okay. And in your testimony, you spoke about that the State Rules Act and state rule on rulemaking 1.24.10, I believe, did not specifically state that definitions that weren't used in a rule can't be, or something along those lines, that it was not clear structured in the State Rules Act or 1.24.10.
I apologize. Can you repeat that again?
Is that so? Your testimony was somewhat along the lines that there wasn't clear statutory or in MAC language whether a definition that's not used in a rule could or could not be in the rule.
Commissioner Dominguez, yes, I referred to the regulation for New Mexico Administrative Code, which you're correct in my testimony, it's 1.24.10. And I believe it may be section or subsection 12.
12.
So I've gone through that time and time again, because this is, I think, my 7th rulemaking. And I wanted to make sure I understand the concern, and we had weighed it pretty heavily when we were developing, particularly the definitions for applications. And we did refer to this New Mexico Administrative Code regulation. I do work with state records regularly to ensure that what we're doing is not outside of the style and format that's required under NMAC, and they really are my go-to for meeting those requirements. And so there is nothing in the regulation that prohibits or discusses whether or not a definition has to be in the rule itself. I would also like to add that the implementation of these applications is not necessarily for future implementation. It's for current implementation of our discharge permits. I manage 95 plus discharge permits. I have 4 applications sitting on my desk for new discharges. Domestic wastewater reuse occurs in the state of in New Mexico, and I believe it's in my direct testimony as to an estimated amount of volume that I can look it up. It's millions of gallons a day of domestic reuse that's going out onto golf courses, parks, schools. Some entire communities use all outdoor watering with domestic wastewater reuse. These terms are very specific to current implementation of discharge permits and to help these regulated communities understand, based on risk, what kind of conditions are in their permits. Currently, everything goes through me and I try and keep it aligned. Public doesn't have a say as to what that is. That's why these applications in particular may not be referenced in the rule, but they are critical for our implementation for protection of groundwater. Probably went a little over on that one.
No, that helps provide perspective of where you guys are coming from. It's not necessarily just focused on produced water, correct?
That is correct.
And I think that's where I'll let the regulated community speak for them, but you hear comments from the general public that are focused on produced water. Your rule when you came out with that broadened to address water reuse. And there may be a disconnect with the general public between water reuse as a whole and produced water. And that may be problematic for all of us.
Yeah, I would like to reiterate, this is a water reuse rule supplemental to assist our permits, not a produced water rule.
Thank you. And I believe most of us up here understand that. I'm not for sure that the general public gets that grasp on it. Now, reflecting back to the 95 permits that you spoke of that are probably permitted under what, 20.6.2?
Correct.
If a discharge is permitted under a particular rule, would it not be more beneficial for that regulated community that's operating under, let's say, 20.6.2 for that needed definition to be placed in 20.6.2 versus a separate rule? Granted, it's a supplemental rule, but I'm viewing it from the regulated community standpoint that they're not having to do this, figure out how they have to comply.
Commissioner Dominguez, we did consider whether we should include this language, including the produced water, because of the Produced Water Act and Water Quality Act, whether we should try to come to the commission with an amended version of 20.6.2 and MAC. However, if you've looked at 20.6.2, it covers a broad range of activities to protect ground and surface water. And working with the regulated community for over, I think about 20, well over 20 years now, that can cause problems both for the regulator as well as for the person who has to adhere to those regulations. Having a supplemental rule that's specific to water reuse is much more concise and direct for that regulated community. Being able to point to these definitions, and when we we build out the other sections of it, when that's mature enough, that will be so critical for helping in implementation and compliance. One of my issues as a regulator is trying to show people where this rule exists and why it exists, and fumbling through 20.6.2, which covers everything from permitting to federal NPDES permits to abatement. It's long, it's complex, and it would just add to more confusion, in my personal opinion, working with the communities, than to have one regulation based on the area of interest that they have for the particular wastewater type that they have, which poses a, a similar risk to others of their type.
If I could just add on to that, the arguments regarding including definitions in a regulation that don't exist in the regulation would still be valid in 20.6.2. We were trying to choose between the difficult and the ultimately insanely difficult. We chose the easier of the two.
Yeah, granted, I understand no one wants to open 20.6.2 back or something along those lines. So I understand that aspect. Also in your testimony, you reflected on the legislative drafting manual. And when there is not clarity in statute or rules for many things, I know before this commission, there's times that councils will say, well, lack of clarity, we looked at the Administrative Procedures Act, which is not part of our role, but they look for it to guide. I think the legislative drafting manual is exactly that, guidance, and the lack of clarity within a rule or act. It's a guidance to go to. Be a little no different than utilizing the Uniform Statutes and Rules Construction Act that gives guidance on things, and in particular within it, the principle of construction section states a statute or rule is constructed to give effect to its entire content. Getting back to, if we've got definitions that don't apply in that rule but apply somewhere else, if we're almost skirting the intent of the Uniform Statutes and Rules Construction Act. Those items give me pause, and something I'm going to have to look at real close before we move forward with our suggestion. And with that, I will give you a breather with my line of questioning. And thank the panel for indulging my questions. Thank you, Madam Chair.
Thank you, Commissioner Dominguez. Let's take a 10-minute break and we'll come back to more commission questions.
Well, I see that.
No, I think you showed everybody you do your homework. Which is good.
This thing, I want to. Lot of this